is that I see a lot of people, I guess, a lot of challenges when it comes to the application. My name is Mohamed Bayad, and this is Monday Legal.
Good morning. As you know, every week I invite a guest. The guest is a friend of mine, is a very special guest, is Mr. Mohamed Bayad. He is working for the engineering office as the Director of Procurement and Contracts, and he is a mediator and a contracts expert. Thank you very much for coming and attending with us for Monday Legal.
Shukran, Ahmed. Pleased to meet you. Mohamed Bayad, Director of Procurement and Contracts, mediator and contract management expert. It's a long-awaited meeting, actually. I've been trying to arrange this for the past couple of months.
I understand that you're always busy and it's not very easy to work for the
timing and all. Yes, it's a hot topic and very interesting for me. For the past, let's say, 15 years in the UAE, I was dedicated only to focus on the mysteries and resolve the puzzles of that topic, which is construction disputes. That's why I named the discussion today as ways to resolve. Back in 2013, I registered in MSc in Construction Law and Dispute Resolution in British University in Dubai, just to study the construction law. And that was the first module. I finished this module and I quit that MSc. I quit mainly because of King's College has withdrawn their association with the British University in Dubai for so many reasons, but I got what I wanted to take out of the 5 modules instead of continuing to the MSc. Later on, I joined the CIARB, Chartered Institute of Arbitrators, to study mediation. There is something missing, actually, what is known in whole of the world up to, let's say, 1 year ago, because there is a shift currently we are practicing in the market and seeing. So for the past 10 years, let's say, you'll always see arbitration or litigation are the only 2 methods to settle the disputes. First, arbitration is a well-known procedures, and the arbitration award is recognized by court, and that's it. Or else the litigation procedures. So you find the customers currently, they don't want to get exposed by going to court to settle any dispute. They have only one way, which is arbitration, because of the process itself. So it became a legal practice that everyone should either, if the conflict is dispute is in a small value, or just leave it, because they don't want to spend 500,000 or 1 million to get to a decision where the dispute is on 1 million dirham itself. And especially here, for example, the International Arbitration Center, you pay 50, 100,000, 100,000, then again you top up, appoint one arbitrator or...
you end up paying a very high amount. But what about handling such disputes with courts? Because the court has the right to appoint an engineering expert, and the engineering expert will be a qualified professional or a company who will have this case to study, and then they will give their opinion. I understand that it can take also years in court, but I think as a process, it exists. Go to see a lot of conflicts going to court more than arbitration, or you find arbitration having much more percentage of these conflicts?
Arbitration is the more percentage. Actually, see, it depends on the disputed parties, whether some of the developers, they don't want their name to come in the court or in the newspaper or in the social media that there's because the market here to a certain extent in Dubai is well known. So it depends on the dispute itself or the both parties. But in most of the cases, they go arbitration because it's confidential in nature. Now, when you talk about arbitration, you go for 16 or 18 months as minimum duration to settle. On the other hand, you go to court. The court will appoint the court expert. And since February 2021, Dubai courts, for example, the claimant should attach with his claim a report from a consultant of that
an independent expert.
Dependent expert report as part of the claim documents or the case documents. And that will be subject to the review of the court expert. And the court expert may give you, unfortunately, actually we are telling, I've seen so many court expert determinations which are technically, I'm not telling legally, it's technically or from engineering or contract administration perspective are wrong. That may lead to wrong judgment at the end of the day. Wrong judgment already. Then you go to the court of appeal, and then again it may not settle, and move from that court to that court. And at the end of the day, you may spend 3 years.
There's always a huge gap between the client and the consultant, let's say the whoever is monitoring the project itself, and there's a phase where the trust is broken because of delay or because of different materials or because of anything that can happen between the client and the consultant or the contractor. And when this link is broken, we always come in the picture. Like, I'm going to send you my lawyer. So the lawyers come, legal notices start to be thrown in front of each other. And then we try as much as we can to put the parties together to settle. And in most cases, both parties have an engineer, have an expert in the room, but they're still not able to find a solution, an amicable solution. Why do you think this is happening? Since you're saying the technical part is needed.
This is happening, see, what is right remains right. There is no point to get the 2 parties already and see if the claim is an X amount, you divide it by 50% and 50% and settle, shake hands, finished. Nobody will do this except very rare, and in case they have future engagement and some other projects, they might set it to that extent. You have to explain and convince both parties that the real entitlement is this value and real entitlement is this value, in case it's a quantum already to be finalized from that perspective. From that perspective, this will come the mediation or negotiation or adjudication or conciliation will take place. For example, adjudication or mini trial. It is a normal process similar to adjudication is similar to court procedures, and mini trial is similar to the arbitration procedures, which is both actually are similar, that require third-party opinion. So let's go back to the reasons. Now, the consultants are not aware that which alternative dispute resolution that needs to be used here in order to settle that dispute, plus the market initiations also. Because arbitration is the only thing recognized by court as binding on both parties through the arbitration hour. The court will check normal process that has been followed already. Tick, 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 yes, yes, yes. No confidentiality, whatever like that. They have 4 or 5, this one. And at the end of the day, agree the arbitration award is like that. They enforce it in case either party is not willing to accept. All other alternative dispute resolutions out of 6 or 7 other methods are not recognized by court until it's binding. Here we are talking about something, the difference between third-party opinion and third-party determination. So the solution is that you made the other alternative dispute resolution being used as a determination, not only an opinion. So it becomes binding already, and both parties will sign. And in case this third party come to a conclusion that 1, 2, 3, 4, we sign, that we abide by this decision. Then it becomes binding on both parts, which is the current direction already of the whole market, because of the weight and unnecessary cases that are going to court that had extra burden impact on the legal system of the country itself. And that's worldwide.
But isn't it very similar to what the arbitration is doing? Because the arbitration is binding for the parties.
Yes, of course. But mediation, for example, is shorter duration with less process, introduction, settings, one meeting, both parties, separate meeting, comments, discussions, again sharing opinions, separate meetings, discussions, again both meetings, already then the things. By the time you show both parties the missing part and convince them that this is your real entitlement because of 1, 2, 3, 4, the guys will agree and will cancel. If the arbitration is ongoing, they will cancel the arbitration, will cancel the case in the court, and that's it. And they will shake hands in the meeting itself. So that's why that's where the contract administrators or contract managers role comes as essential already to manage also the construction disputes. That's always where I keep on asking myself who really should manage and lead the construction dispute. Is it a professional contract administrator with reasonable legal background or qualified lawyer for construction disputes? And as an engineer after 10 years searching in this field, I put my opinion in the first option, of course, with no doubt, especially if you have a proper legal background that requires the guidance to take the proper decision, because construction disputes are in nature 90% of technical perspective and maybe 5 to 10% of legal perspective. And by the time lawyers actually come to the picture, both parties, they don't talk even to each other unless through the lawyer, and everyone is afraid to make a mistake and all like this. And it's not like that. It could be the dispute could be on a small value, but and the solution is there, and it became an issue. And it became an issue, and it prolonged different things. Like, maybe both parties, they have another project, and the client or the employer, for example, hold the payment for the contractor, and the project will get suspended, awaiting the judgment of the court or the arbitration award in order to cover the remaining amount. They found different solutions already, and find different subcontractors will get stuck with the payments and so on. And especially if the company is a huge contractor or one of the pillars in the market, it becomes a real issue and may affect different subcontractors and suppliers in the market. And I've seen this.
It is very difficult to imagine that the client or the customer in the end is going to give the conflict in the hands of the contracts administrator with an engineering background whenever there's a conflict, because whenever there's a conflict, it's already understood that there's a deadlock. So they need the lawyers to come in. Everybody have to flex with the legal knowledge and see where it takes us. Yes, in the middle of the dispute, we can look at the numbers. We'll then come to the technical side and see where we take your opinion and so on. You agree otherwise? You think that the technical expertise and the contracts administrator should take over before the lawyers gets involved?
See, you have two scenarios, or you have that scenario is the one applicable or available when the conflict is not resolved and it became a dispute. By the time the lawyers are involved already, or arbitrators, the matter is already very complicated and it gone by force to a certain direction. Well, FEDEC found the solution for this by providing DAP, which is Dispute Avoidance Adjudication Board. Within the contract itself, at the beginning, at the time the both parties, employer and main contractor, for example, signed the agreement, you find the Dispute Avoidance Adjudication Board.
Does it make a difference? Does it make a big difference, the value of the project, where you would give a different recommendation on the alternative dispute resolution? So would you say a project of $100 million is different than a project of 100 million dirham, and then there is a different alternative dispute resolution, mediation, or anything else?
It doesn't. It is a nature of the conflict or a dispute. Then you propose the suitable alternative dispute resolution to settle, applicable to the dispute itself, not related directly to the value of the project or value of the dispute even. I used to tell the pace of the construction work in this part of the world, let's say, is not matching the proper way to settle the disputes. And that the measures being taken for dispute settlement are the same since 50 years and now. So this has to be changed, because you cannot change the construction process through specific mechanism to match the way to settle the dispute if the dispute is there. That's why they always call the mediation clause and the dispute management clauses in the contract as midnight clauses. And midnight clauses, you'll find like 2 lines describing the method of managing the disputes, and that's it. They don't talk about the arbitration already. They don't provide any alternative dispute resolution. You don't have dispute avoidance adjudication board in the contract specified institute itself. You don't specify the seat of arbitration, the law of arbitration, governing law of arbitration in the contract. You don't find those details. And at the end of the day, when you're talking about a project that require, let's say, involvement of an international arbitration or something, and at that time you may get stuck if your contract doesn't support you, and you end up in a different story altogether. But the solutions are always there. It depends on which mechanism of the alternative dispute resolution to adapt to already. That's the best method to resolve that specific dispute. That's it. With less people in the market knowing this at this point of time, it makes it difficult also to reach to a settlement.
Yeah. Does it put a heavy weight on the legal system itself? I can imagine if every single construction obstacle will come to a conflict, then the court will be overwhelmed and the arbitration center will be overwhelmed with the number of cases that is unlimited.
Yes.
And of course, each of these cases will need the protocol, all the procedures, step by step, and then it goes to mediate to the expert level and so on and so forth. And I can imagine that the court... the cost of this on the economy is quite high, plus the cost of the losses that's happening because of the construction itself. And I can imagine that the mediation could be a solution, not just to save money for the both parties as an employer, construction company, and consultant, and so on. They could actually help the economy in general to lose less money in the process, which is a good way. Do you see more and more that the market is developing in this regard? Do you see that
that direction? I saw the market improvement since almost a year towards that direction, to minimize and try to explore different options to settle rather than arbitration and litigation.
And this happening by the big developers or across the board?
It's government initiation in the first place. You see the governments or the courts already having service level agreement with the specific engineering consultants firm, with other firms and all.
No, I meant would the developers enforce this with the construction contracts that they have, that they put these clauses with alternative dispute resolution measures as the first step, or this is something that the government already is forcing?
It is different from one developer and another. It depends on his awareness and up to what extent he suffered, let's say, from earlier back days in construction disputes, and his experience and exposure as well. Confidentiality is an important factor. And the strength of his qualified engineers already, or contract administrators and all. The answer to your first question, we find, or I saw actually, almost 50% of the cases that are going to escalated to lawyers to settle, or arbitration, or to court, or litigation, should not be even escalated to lawyers at the first place, because the settlement is there. And neither party is well aware because of less experience of his third-party consultant or his specific own team to manage the dispute to a reasonable...
Can you give me an example of something that is a bit technical? You don't have to tell me a technical part, but something that maybe the employer, the construction company, as well as the lawyer, wouldn't be able to manage without having a mediator who have a technical experience in the middle. I can understand that might be a bit technical, but just an easy example. Tell me what could be the conflict resolved easier by a mediator.
See, we discussed the reasons for the conflicts in construction disputes. The main reason, for example, would be the extension of time. That's why it requires specific specialization from engineering perspective, I mean. and prolongation cost with cost or without cost. You find liquidated damages applied. You find a delay in payment by the employer. I find so many reasons that all of them together could be there already in a complicated manner with insurance and all, and legal also breaching the contract, some other contract commitments or liabilities and all.
Having someone with technical expertise together with contracts, and as well as have seen a lot of disputes being resolved is going to be very important and actually beneficial for both parties in the conflict. And of course, I always advise to go for mediation before arbitration or before courts, because I think in courts no one wins. So I think outside of court is settlement is always a smart way to go about something like that. So whenever there is a dispute on the horizon, what would you advise the conflicting parties to do? Would you advise immediately to go to mediation or immediately to go to the alternative dispute resolutions like what you mentioned, and before they go to arbitration or courts? What would be the first step that they need to do?
It's not mandatory or it's not common in the market that every employer should have his own QS team to manage the contracts or construction contracts for them. With recent market initiation, you find consultants from engineering background. That firm is made only to manage disputes or construction disputes up to the resolution stage. Every employer should have a collaboration or an agreement with certain companies for his construction projects. Those people, they advise from engineering perspective or contract management perspective, avoiding all the conflicts. And if the conflict is not sorted out or it led to a dispute, they manage to resolve the dispute without arbitration or without even mediation, or they process the mediation itself in case the dispute is there without even going to court and all like this.
Well, thank you very much for your contribution and for your time. We're very happy to have you here.
I'm so happy to come, and wish to see you again on different topics. Just keep me exploring the market and all like this, and within the upcoming few months I'll come back to you with updated ideas and directions.
Inshallah. Thank you so much. It's amazing. Well, this is your dose from Monday Legal. See you next week.